Counsel for Austin Commercial, would you like to reserve any time for rebuttal?
Yes, I'd like to ask for 5 minutes, please.
All right. Go ahead, counsel.
Thank you. May it please the court and counsel. My name is Christina Lim, and I represent the petitioner, Austin Commercial. In this complex construction litigation case, the trial court disregarded the rules of civil procedure as they pertain to expert disclosure, disregarded its own scheduling order, and permitted an early deposition of someone who's likely to be disclosed as an expert witness, and thereby invading the work product privilege of Austin Commercial. Essentially, the order turns the expert disclosure process on its head and forces the premature deposition of Austin's consultant.
Okay, so I have a question for you. So, oops, I apologize.
That was my 15 minutes.
Yeah, time flies, doesn't it? That was an incorrect technical issue. You still have 14 minutes. Now I lost my train of thought, and I'll make up the time that it takes me to find it by giving you some extra time at the end of your argument. This is a certiorari review, and Judge?
No, if you remembered, I was going to ask a question while you.
Certiorari, and I don't know if it's an elephant in the room, but I'll just start with the word 99, and that's a thrown around in the briefs as something your client used as the number of the percentage of confidence that they will call this witness. And I'm wondering why then if this can be seen as injury that would last for the duration of the litigation for the purpose of invoking certiorari jurisdiction.
Absolutely, Your Honor. And here's the issue, I think. And if I may, can I provide a little bit of background on what the current status is of the deadlines for expert disclosure and follow up with your answering your own
whatever is in the filings, we can just rely on those. I don't want to hear anything outside the record.
Okay. So the scheduling order, Rule 1.200D provides for the scheduling order to govern the orderly disclosure of experts, their opinions, and when they may be deposed. And so here, what essentially this order does, it dispenses with the scheduling order as to Austin Commercial and requires the premature disclosure of what's considered work product privilege at this time. And that's in a situation here where the other parties, Mass Mutual, as well as Austin subcontractors, have affirmative claims against Austin Commercial. It provides them with the benefit of the work product that's protected when they are preparing their affirmative expert reports, which at this stage is due June 1st. And then the premature discovery of any consultant by Austin Commercials is then divulged to the benefit of its adversaries. And that turns the entire expert disclosure process on its head.
Ms. Lam, I understand your argument on the sequencing, but I think Judge Atkinson shares my concern here. I am struggling with concluding that the jurisdictional element of irreparable harm that cannot be cured on plenary appeal is going to occur when it is 99. I don't think there's any dispute really that AMS is going to wind up being a testifying expert. So it's not really a withdrawn consultant, an expert that's going to remain a consulting expert or who's disclosed as a testifying expert and then later withdrawn. This testimony is coming out. And so I'm following what you're saying about the counterclaim. We know there's a lot more going on in this case than we've seen in this record in terms of counterclaims and whatnot. But in the rest of it, it boils down to we're out of sequence and they're going to find out something that they were going to find out anyway. But because of that, Austin is irreparably harmed. And it sounds great in the ether, but I'm having a hard time making it practically applicable in the context of the jurisdictional showing that's required here. Help me out.
Yes, absolutely. I do believe, as I said, that the premature disclosure amounts to irreparable harm because, for instance, in this record, there are still at least 20 fact witnesses to be deposed between now and the June 1st disclosure date for the expert opinions. I believe Austin Commercial's consultant is entitled to rely on the entire factual record. And I also believe that the 20 fact witnesses that are deposed, in a typical ordinary matter, they don't have the benefit of the adversary's consultant's work product at the time they testify.
But Ms. Lim, isn't there also an aspect here where they're wearing two hats? I mean, they were around, they were assisting up to a certain point. I know you now want to don them with this new hat of being an expert, but doesn't MassMutual shouldn't they have an opportunity to have discovery about things that happened before? And I think even in the hearing, they agreed that they weren't going to be asking them about their expert opinion and that sort of thing at that point. Doesn't that put the other party at a disadvantage to not be able to ask all of their witnesses what's going on? And for that reason, why is there irreparable harm?
Well, I believe that the two hats argument is where MassMutual is relying on the City of Jacksonville case, where the fire chief was a regular employee of the fire department, at some point retained for purposes or in anticipation of litigation, and where the court permitted discovery into the time where he was just a regular employee. I think the situation here is different. AMS was always retained in anticipation of litigation, and David Yeage's uncontroverted declaration asserts that AMS was never just a consultant on the on the construction project prior to this situation.
But didn't they, I mean, they were included in a lot of communications and other things that you wouldn't ordinarily include your expert on for litigation at that juncture.
Well,
so
I think
were they presented to the other parties as being, this is our expert for litigation purposes, or were they presented as this is somebody that we're bringing in to assist us with our claim?
Well, I think that the record is a little thin in terms of what's asserted in the answer brief in terms of presentations made, participation, and communications. I don't think the privilege law is supported MassMutual's argument there. But it puts in an expert-driven case like this as a complex construction delay case that's expert-driven, and where a party has to submit for instance, an insurance claim prior to litigation, give notice prior to litigation, or participate in settlement communications. They cannot show up with that insurance claim unsupported. They can't say, we were delayed 69 days, we think it's going to be about 5 million. In order to submit an insurance claim, they have to substantiate it. And I don't believe that the provision of two schedule analysis related to two rain events waives the entire work product privilege as to the consultant's entire file. And I think that gets us back to what the real issue is here, is the scope of the topics on the deposition notice and the documents requested. MassMutual has represented at the trial court and somewhat in their answer brief that they're really just looking to depose AMS as a fact witness, and just for a limited time period. Really,
Ms. Lam, if they had amended the notice consistent with what has been represented to some extent in the briefing and I believe was discussed at the hearing, such that AMS was just being deposed on the fact issues surrounding the two reports, and that's a sort of parallel to the City of Jacksonville type of outcome, we wouldn't be here, right?
I would tend to agree that had that been the issue, or had that been the situation, I don't think the parties would be here, and that's why I'm reluctant to.
And we're kind of handicapped because we can either quash the order or affirm, but we can't fix it to make it palatable.
Correct.
In this procedural context.
But I do think here that the deposition notice with the subject matter that was in that notice that is the one that's before the court, that is the information that would be divulged. And so I understand that the court's only relief here would be to quash the order. And quite frankly, the parties could go back to the trial court, and Mass Mutual could amend its deposition notice, as it could have at any point up until that point. It could have amended its deposition notice to say, here are the two rain events we're interested in. But even their argument, though, that they just want to depose them as a fact witness would still, to some extent, create a showing of exceptional circumstances. But I do think, though, that there has been no attempt. We saw it in the hearing transcript and the communication prior to the noticing of the deposition. Representations were made that, oh, this is just a fact witness and just for this limited purpose. But the deposition notice governs. When the parties are sitting at the deposition or forced to divulge their entire expert or consultant file, then it's the document, the schedules in the deposition notice that governs. It's not what someone said at a hearing a couple of weeks ago. I mean, that's just the situation. And that is the notice. The order allowed that deposition to proceed. It allowed that document request to compel production of those documents. And that's where the problem is. The subject matter of the deposition notice is at the core of the issue here. And Mass Mutual up until now has made no attempt to align that deposition notice with what it has made representations at hearings, that it's really just seeking fact information, or that it's really just seeking a very limited time period. And for instance, the topics in the deposition notice are not limited in time. And I think they're worth taking a glance at. They are clearly what is considered expert discovery, and includes all information or communications between and among you or your agents, including the counsel between Austin Commercial and AMS. That is not fact witness discovery. It also seeks any and all contracts between AMS and Austin, which would include engagement letters, scope of the engagement, etc. And there's absolutely no time limitation to those deposition topics. There's no limitation to the subject matter. It does not just relate to the two schedule analysis. In fact, those two schedule analyses are not mentioned anywhere in the Schedule A or B. There's not any request to know anything about the facts. Those schedule analyses were related to the two rain events, how they impacted the first and the second milestone, including the completion of the ballrooms and specific facts like that. And if that were really what Mass Mutual was looking for, it could have catered or described that in the deposition topics in a way that reflected what they're claiming is really just fact witness discovery.
Yeah, so your argument that I don't know if the dots are firmly connected, but that there's a chronology issue, meaning this is tantamount, well, not tantamount, but in so many words, a request to depose an expert. This expert has not yet been disclosed, but you concede that there's only 1% chance that he will not be disclosed as an expert. But in order to get irreparable harm, you rely on a work product, a work product assertion, which is connected but not the same thing as saying. In other words, it seemed to me that the error, meaning the objection to the protective order, was, hey, this gentleman is not an expert yet. But the harm is something separate, which is among the documents requested to be produced for work product. Is there anything else? And what as Judge LaBritte said, we have to quash an entire order based on harm that will last throughout the duration of the litigation. Can you connect those dots, or is there anything else that besides the work product, which could be handled by objecting to certain documents on work product basis?
Well, I think the other parties with affirmative claims against Austin Commercial are, at an unfair advantage, and Austin Commercial is an unfair disadvantage and harmed by those experts having access to what's work product privilege. I mean, one of the rationales behind the work product privilege is that one party is not entitled to prepare its case through the investigative work of its adversary. And where in these highly expert-driven cases, where everyone is relying on the expert disclosure schedule, suspending the protection of the third amended scheduling report causes harm to Austin Commercial because it has its entire investigative file. It's part of its litigation strategy, and that is prematurely divulged before it has an opportunity to hear all the facts from the other fact witnesses, form its opinions, and essentially gives its adversaries an opportunity to rebut its investigative work before it can even present its affirmative expert report.
You're there. In addition to the possibility of the disclosure of work product, there is a rule-created entitlement for a party to keep its expert witnesses close to its vest until such time as they're ready to be disclosed. Is that a rough approximation of the?
Absolutely, absolutely, Your Honor. And I think that's part of the adversary system, that a party is entitled to prepare its case protected under the work product privilege under the adversary system until the orderly disclosure of such work product, such strategy, and such opinion as it's set forth in the order.
You've gone about a minute and 30 seconds into your time, but it's my fault, so I'll just give that to counsel for the opposing party. Would you like to reserve the 5 minutes?
Yes, please.
And okay, thank you. Counsel for the appellee.
Good afternoon, Your Honors. My name is Christopher Lisi, and I represent the respondent, Mass Mutual. May it please the court and counsel. We're here today to discuss Austin's efforts to block discovery into pre-litigation work that was done for Austin's business purposes, that Austin never contended was privileged or protectable at the time, and that Austin voluntarily provided to Mass Mutual twice, many months apart, back in 2018. And moreover, Austin asked Mass Mutual to rely on that work in issuing a favorable business determination for Austin. And what Austin is trying to do now is retroactively shield discovery into that work by declaring that AMS, the party that prepared the reports, is its testifying expert, which according to Austin would block all discovery into AMS's work, even the non-privileged work that Austin voluntarily provided to us.
Well, is that really Austin's position? I think we just had that colloquy where we agreed that we probably wouldn't be here if Mass Mutual had taken out the things like conversations with your attorneys and documents exchanged, traditional expert testimony areas, and limited this to the fact issues surrounding the two reports.
Thank you, Your Honor. I respectfully, I do think it is Austin's position. I'm hearing that for the first time today. If it had been that easy, and I want to speak to the subject. Well,
let me pause. You're hearing for the first time, and I want to understand what you mean. I mean, what was in the briefs was that may not have been phrased in the way it was discussed today, which was that the deposition request read like a deposition of an expert witness, which is tantamount to saying today that if what had been sought was facts within the knowledge of this fact witness, then it would be different. So I'm not sure this is the first time this concept has been discussed.
Thank you, Your Honor. I was referring to the first time hearing that if we had amended the notice, that we would have avoided the entire exercise. I'd like to turn, I'll do it right now, to the deposition notice. You can find it in the record. The relevant page starts at page 66 of the appendix. And I'm just going to paraphrase the 6 or 7 topics for testimony. Number 1, what did you do? Number 2, what did you do on this construction project? Number 3, what did you see? what did you know? Who did you talk to while you were doing that work? Number 4, what did you talk about with others? Number 5, what contracts are there that set out what you were supposed to do? Number 6, how much did you get paid? And number 7, documents that you produce in response to the subpoena. There isn't any indication in that notice that we're asking for opinions that they're to provide as a witness in this litigation, what they've done to prepare for trial, or what the trial testimony will be. And I'd point your honors to the last page of the notice on page 72. We time limited the requests to end in 2018. That predates Austin's lawsuit against MassMutual, and it corresponds to the—
But wait, you can't really disagree that the notice seeks seeks documents concerning communications with Austin's counsel, right?
It does, Your Honor, yes.
And that's not fact witness.
It may be if the documents aren't privileged. And typically what we would do in this situation and what the parties would do, if one party believed that a notice called for documents that were protected, and that happens all the time, they would serve objections, or they would have a conference and they would withhold those documents and put them on a privilege log. And Austin could have done that here. So there isn't any forced disclosure.
Well, they did do that and you weren't happy with it. And that sort of seemed to have gotten subsumed in the ruling on the protective order. That's my read of what transpired there. So help me out with that. I mean, it does seem to me that given the colloquy at the hearing where MassMutual said, I only want fact information, and understanding the sensitivity of this from Austin's perspective, given everything else that's going on in the litigation, that it would have been easy enough for MassMutual to amend that notice and limit it to the bifurcated concept that is sort of recognized in City of Jacksonville. And that's what I'm struggling with here, because it's almost like we're being asked to be a second trial judge and say, well, you know, you all are fighting about silly stuff concerning sequencing, and it's easy enough to bifurcate this deposition and let you get the fact information that you would like about those 2 reports. The onus is on you, though. And
that's, Your Honor, why we've tried to be exceptionally clear about what it is we're interested in here. Our read of the notice as it's written is not one that's directed towards an expert who's going to testify in the litigation. And we've tried to clarify that through representations that we've made both in our papers and on the hearing below, and representations that I'm making right now about what it is that we're interested in. Not here to point fingers, but I don't believe, or at least I don't recall ever hearing from Austin at any point that if we simply amended the notice that we could have avoided all of this. So I don't think respectfully that's what this is really about. I think what this is about is Austin doesn't want us to take depositions of their witnesses in the order that we would prefer. They would prefer to do it in the order that they think is most advantageous for their case. I think that's really what's at issue here.
So what you said, nothing in the request suggests definitively that it was that of an expert witness, but what in it suggests that it was seeking to just discover facts supporting the reports that had already been produced?
Well, we have
where in there that suggests this was a fact witness being sought to be deposed.
Certainly, Your Honor. For example, number 2 and number 3 call for
all information or communications.
I'm on page 66 of the appendix, and I'm looking at topic 2 and topic 3.
Oh, I'm sorry. I have a. Let me get there. Sorry, you just read it off because I'm at a recapitulation somewhere in the brief. So
certainly. Number 3, for example, reads testimony about the construction of the Lanai Tower at the JW Marriott Marco Island Beach Resort, and that's the construction project in dispute. We know from the 2 reports that AMS prepared that were provided to us that AMS visited the construction site during the relevant time period, that they walked the job site, that they talked to people who were working on the construction project. and that they gathered information. And just like any other person who had a conversation about a disputed issue, we're entitled to ask about those questions. So that's an example of the kind of fact information that we're seeking. Just another one, number 4, it's a few words long, I'll shorten it. All information or communications between or among you or your agents and a number of other people, on the one hand, and often on the other hand.
But you've got this document request that is just wildly overbroad for purposes of a fact witness, and you're asking the witness to be prepared to testify concerning those documents. All documents and communications relating to the projects, including but not limited to AMS's work, any working file concerning the project. These are things that are going to result in the disclosure of expert work at a time that it is at least technically premature in the case management sequence.
Respectfully, I disagree, Your Honor, for a couple of reasons. Number one, they have the ability to object and to not produce either documents or testimony that they believe are inappropriate under the deposition. Number two, it's not an out of sequence deposition. And I think that's a key here, and it was raised during counsel's argument. The same judge that issued the case management order is the trial judge, is the same judge that permitted this discovery to go forward. And that judge has discretion over her docket and her courtroom. This was extensively argued and briefed, and there should be considerable deference afforded to her decision to permit this discovery to go forward.
No, I'm glad you brought that up, because that does bear some clarification. Out of sequence, meaning, this wasn't the time for expert discovery, but the rule says discovery of facts. The rule hinges, according to what I'm reading in the rule, is that it can be obtained only as follows: any person disclosed by interrogatories or otherwise as a person expected to be called as an expert witness. In other words, if the judge have said, well, we're doing this out of order, but their opposing counsel is going to argue that would have been in derogation of the rule, which says this individual is not expected to be called as a witness, therefore they can't that you can't depose him according to 1.290 B5.
Well, and in fact, Your Honor, Alston cites to the committee notes in its opening brief at page 18. Those notes support our argument because the rule's purpose is to allow, without leave of court, experts to be deposed in a particular order. But we have leave of court here. The court has endorsed the sequence, and I just want to be crystal clear on one point. This isn't going to be an expert deposition of a testifying witness at trial. And again, I want to make sure that I emphasize that point. We're going to be asking, if the court denies the petition and the deposition proceeds, we're going to be asking questions about the work that AMS did during the relevant time period. We are not going to be asking questions about litigation opinions that AMS may or may not offer at trial. And I think that's a critical distinction, because all of the labels that have been applied here, like non-testifying expert and consulting expert, create a bit of opaqueness that I don't think is helpful to understanding the issue. We have an entity that prepared work that Alston sent to us and asked us to rely on. We have questions about that work, and we're entitled to ask questions to understand it better.
Going back to, I'm sorry, Mr. Lucy, going back to the issue of the breadth of the deposition notice that you all are traveling on, and your position is, they can object and whatever, and my concern with regard to the deposition notice and its breadth is the inclusion of these broad categories of documents that clearly go to expert files and so forth. What is your interpretation or your position with respect to the order that the trial judge actually signed, where she struck the third paragraph of the order that presumably was prepared by some lawyer, maybe you, that says calls for the production of the documents. Does that mean AMS doesn't have to bring the documents, or what's your position on how that plays?
Thank you for the question. I did have a hand in preparing the order. That was a correct assumption. Our interpretation of that is that the first paragraph is important and that Austin's motion is denied. And what that means to us is that the subpoena and the accompanying request for documents is a valid subpoena, and that Austin or AMS, pardon me, has to appear for a deposition in paragraph 2. The striking of paragraph 3, it's our position that the documents didn't have to be produced on a date certain, not that documents don't have to be produced. But again, as with any
your position is that if this petition is denied, Austin's job is to show up at the deposition with the documents, and to the extent it intends not to allow you to see them or testify about the contents of them, it can log them on a privilege log and object, be instructed not to answer.
And I think the procedure appropriately calls for that, Your Honor. So what we would expect to happen if the petition is denied is that we would have a deposition of AMS, and AMS would show up to testify, and it would produce documents. And if Austin is going to take the position, as it sounds like it will, that some of those documents are protected for whatever reason, they're entitled to put those documents on a privilege log. We think it's pretty clear that—
Are they entitled to instruct the witness not to answer about the contents of those documents?
I think that they would be if the question calls for inappropriate information. I think a counsel always has that opportunity and ability at a deposition. However—
I'm just trying to see the next case we're going to get on this dispute.
I understand. I think part of the reason why we can delineate a clear distinction is because Austin is taking the position that the reports are not privileged. And that's at page 22 of their petition. I think that's a critical distinction. So if the reports aren't privileged because they were provided to us voluntarily, and Austin now admits that they aren't, we should be able to ask questions about work in that regard.
I don't think anybody seriously believes that Austin shouldn't answer questions about the reports. I think the question, and I think I'll let Austin's counsel speak to this on rebuttal, but.
Well, so far we haven't had that opportunity. So I would respectfully submit there appears to be a dispute. If we had been afforded the opportunity to ask questions about the report and the work that AMS did during the relevant time period, not work that it may be doing as an expert witness in this litigation, I don't think we'd be having this discussion today. So I do think there is a bit of a dispute about that. I know I'm coming up on the end of my time. I want to address one point that was raised during counsel's opening argument, and that's the standard of material injury. And it was correctly pointed out, it's material injury for the remainder of the case. And since everybody here seems to agree that AMS will be made a witness at some point in the case, there can't be material injury for the provision of documents or information.
Well, but that's not what she's saying. What she's saying is that divulging this work product to Austin's adversaries before the expert has actually been disclosed and opined is potentially damaging in a way that we can't fix on appeal, because it's going to give them a strategic advantage that they wouldn't have otherwise had to rebut Austin's fundamental position with regard to what went wrong here. That's what she's saying, isn't it?
Well, there isn't any work product that's going to be at issue. Again, they've already acknowledged that the reports aren't protected, and therefore the work that goes into the reports aren't protected. The second point about an unfair advantage, I'd refer the panel to the Kaplan case that Austin cited in its papers. It's at page 463 of the decision, and that's another decision that was before the court on a writ petition just like this one over the disqualification of counsel. And the court there concluded that just because counsel might have some information that could confer a, quote, very strong advantage which they are not entitled to, that itself was not sufficient to warrant disqualification under the standard. So I think, candidly, Your Honor, it's speculative at best that any witnesses would gain any kind of advantage simply because AMS is going to be talking about some of the work that we already have. There isn't any explanation from Austin about how that creates a material risk.
Well, let's stop right there. There's nothing in the request that says that the questions will be confined to the work that you already have, the reports that were submitted for the purpose of the claim.
I'm sorry, Your Honor, I did not hear the first part of your question.
Oh, I'm saying you said, you know, there's no harm, there's no strategic disadvantage to being questioned about work that you already have, but nothing in your request confines the scope of the deposition or product discovery or the production to work you already have. You know, yeah, well, they're conceding you got these reports because we submitted with the claim, but.
Again, I would respectfully disagree.
We're talking about harm. Do we need to take it at face value here? You know,
there are dates in the request, though.
That's what I was going to refer to. There are dates. It's the last item of our subpoena. It's item Z, and it's on page 72 of the record, where we time limit the requests until 2018. And again, 2018 predates the litigation here. Number one. Number two, it corresponds to the date that AMS issued its second report, the report that we have. So respectfully, I would refer Your Honors to that. And again, the representations that we've made all along the way.
Was the original complaint filed in this action?
This is a consolidated action, Your Honor, with 10 or 11 various complaints, but the original Austin complaint was filed, I believe, in January of 2019.
Assuming that the type of harm chronological strategy is something that we could consider as irreparable harm for the purpose of certiorari review. I want to go back to something you said because I did note it when I was looking at this rule, and that is that in B5A2 it says without motion or order of court. And I did admit I first read it the way you did, but I don't read it to say that you can go ahead and depose individuals contemplated by this subsection willy-nilly. If you have, well, not willy-nilly, but the opposite with order of court. That's just saying if they meet the criteria, then you can do it without order of court. Doesn't mean that if they don't meet the right criteria, you can do it with the motion of the court. We're here because we're wondering whether the court improperly allowed it. And the way I read the rule, although it's not completely clear, is that there's the facts known and opinions held by expert. In other words, if it's at this time, it's not a disclosed expert for the purpose of testimony at trial, they can only be obtained when it's been determined that they're expected to be called as a witness. So that doesn't mean that the court can allow the deposition if they're not yet expected to be called as a witness.
Well, I think the court has discretion and considerable latitude to control its schedule and its docket, but I would refer back to what Judge Stargell said about the two hats. That's effectively what we have here. We have a witness who's wearing two hats. They may be a testifying expert, but we know for sure that they have relevant information that isn't protected. And so we're seeking the deposition and the discovery on the second portion of that. That unquestionably is appropriate during fact deposition, which is where we are right now in the case. But again, the court has considerable latitude here. It heard these arguments down below. There were 2 rounds of briefing, in effect, in an argument. And it enters its order that we submit respectfully should be upheld because the petition should be denied. I'm happy to answer more questions from the panel. I do know that I'm over my time.
I allotted some extra because your opposing counsel got some, and I was the reason for you going over. Thank you so much for your argument. Counsel for the appellant.
Thank you, Your Honor. I think what was interesting here is that Mass Mutual's counsel essentially read the deposition topics the way perhaps he wished they were phrased. I think it would have been exceptionally easy for Mass Mutual if the true intent was to just seek factual discovery about those two schedule analysis and how.
What do you say about the date? I mean, the dates are limited to the time where, going back to the hats argument, they're wearing a hat.
Yes, the date.
Not an expert hat.
I'm sorry, I missed the last part.
Not an expert hat. At that point in time, that's what it's focusing on.
Well, the affidavit of David Yagi is uncontroverted that they were retained in anticipation of litigation. But here, while the document requests are time limited, the deposition topics are not, and they would cover the entire time period. But even if
why wouldn't you just object? Like, I mean, I understand what Judge LeBrit's saying. We might see this again. Well, it wouldn't be the first case where things come up multiple times, but the trial judge has a job to do here also. So if they go into certain issues that you object to, that's what you would do. But the argument that somehow you having to disclose your expert now puts you at a disadvantage, how does that not put them at a disadvantage when the person you all chose to use for your construction research and that you use that to disclose to them, they can't now discover at all until they get into the expert phase?
Well, I believe that had the deposition notice specifically stated the facts that counsel is now representing that they were actually looking for, and that they've had the opportunity to amend all along, it would be a different situation. But here, the scope and the subject matter of those Schedule A and Schedule B, the document requests, and the topics is so clearly expert discovery that either counsel will find themselves in a situation where they have to object to every topic, or that they would have to object to put everything on a privilege log. And counsel's suggestion that that should be handled by the trial court in camera inspection is just impracticable here, where the entire notice clearly seeks expert discovery. And
so are you saying that there's nothing that should be discovered at all, and the trial judge isn't capable of sorting through what should and shouldn't be discovered at that point?
No, I'm not. I'm certainly not asserting that, Your Honor. The one thing is the facts, but the facts that could be discoverable. Another thing is the fact that the deposition notice as it is, and which is the order that the trial court allowed that to proceed. And that's what's before the court here. We cannot look at what Mass Mutual wished they had put into the deposition notice. They had every opportunity to be specifically clear about any of the facts that they wanted to depose the witness on. And the fact that they doubled down on this deposition notice and sort of almost blames Austin Commercial as if it's our responsibility to revise their deposition notice. We objected. We went through the entire procedure. The communications are in the record, and they still noticed the deposition for these topics and proceeded all the way to this level, at no point in time amending their notice. And the court allowing this to go forward is in derogation of the rule. And while Mass Mutual is claiming that we want some sort of special treatment or we want to dictate the sequence, no, we just want the same protection under the Third Amendment scheduling order that everybody else gets. And I think the case that Mass Mutual relies on and cited, considering Kaplan versus DeVoster Holmes, it was a case concerning disqualification of opposing counsel based on information that the party had told to their neighbors and everybody else, and they were worried that it might make it to the opposing counsel. That is hardly applicable or instructive here. We're not attempting to disqualify opposing counsel, and we have not divulged our entire consultant file to neighbors and anybody else. So it's inapposite. The bottom line is that this causes material injury that remains throughout the case because Austin Commercial's adversaries will have a strategic advantage, and that causes irreparable harm. And the whole purpose of the work product privilege as it is the immunity from discovery that's necessary to preserve the privacy of an attorney's preparation and to ensure the proper functioning of the adversarial system.
Would you concede that the deposition notice included some information that it was eliciting some information that would be typical of a fact witness. It said the construction at X site. Tell me about the construction at X site.
Well, considering that AMS was hired as a consultant in anticipation of litigation, that would define.
Well, I thought that's where you're going to go. In other words, there are questions that
they could be read that way, Your Honor. I'm sorry. I said they could be read that way, but the uncertainty.
Could be read that way, but what in that your fallback argument to that? In other words, there's two hats. Your fallback argument is that even during the time period that they were hired to create these reports to make this claim, that was in anticipation of litigation.
Correct. I'm sorry.
Okay.
But also the way this question is phrased, there's no temporal limitation to that. There's no time restriction to that. So whatever other services that AMS provided would be included in this, and without the time restriction, it would continue all the way in through to the litigation.
True, but you're also saying that if it preceded the 2018 cutoff, which did only apply to the request for production, not necessarily the questions as to disposition, but that too would fall under 1.280B5 because it was acquired in anticipation litigation.
I believe so, Your Honor. I think, could there be factual circumstances that Mass Mutual would be entitled to depose? I mean, they made no attempt of showing exceptional circumstances. They had plenty of their own representatives available on site and anywhere else. So I don't think they really have a basis for exceptional circumstances. They certainly haven't attempted to argue that.
Well, I've let you both go over, so mostly due to my my questioning. So I think, in fairness, I need to cut you off if you want to wrap up.
Absolutely, Your Honor. Because the order under review causes irreparable harm to Austin Commercial, departs from the essential requirements of the law, Austin Commercial is asking this court to grant the writ of petition for certiorari and quash the order below.
Thank you both.
Thank you.